You've just joined us. Our epic cage battle is about to start. National government versus state government. The result of this battle will decide once and for all who has supreme power. Let's get ready to rumble. Okay, so I'm not going to show you an epic cage fight, but I am going to talk to you about the power struggle between the national and the state government and how the 10th Amendment comes into play. The 10th Amendment says the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. That probably seems pretty obvious, like there's no room for a power struggle, but things might not be as straightforward as they seem. You see, while it says the powers, it doesn't tell you what those powers are, or even what they relate to. Add to that the complexity of the Commerce Clause and the Elastic Clause, and things don't seem so clear anymore. To help us truly understand the 10th Amendment, let's look at its history. The 10th Amendment is the last amendment in the Bill of Rights, which was passed through Congress on September 25, 1789, and ratified on December 15, 1791. The purpose of the Bill of Rights was to protect the people, to make them feel safe and secure, and prevent fear that the national government would suddenly become tyrannical. It was a compromise to get states to approve the Constitution. See, there were these people called Anti-Federalists who worried that the Constitution's national government would be too strong and take away the freedoms earned through the Revolution. The 10th Amendment was meant as a clarification of sorts, to assure those Anti-Federalists that power would be shared between national and state governments. It was part of federalism, a major principle of the Constitution, which divided power between the national and state government. The states were given reserved powers, while the national government was given enumerated powers. The Constitution could not list every power possible, so the 10th Amendment says, look, if the Constitution doesn't say it's an enumerated power, and also doesn't say that the states can't have it, then it becomes the state's power. Sounds like it needs no explaining, right? But wait, let's look at how the courts have interpreted the 10th Amendment. After all, the legislative branch may pass the laws, but the judicial branch decides what the laws mean. First up, National League of Cities versus Usury, 1976. In this case, the Supreme Court struck down provisions of a federal government law that extended minimum wage protection to almost all state and municipal employees. The court acknowledged the Commerce Clause, but declared that the federal government couldn't tell the states what they must pay their own employees. If this were a cage fight, that would be a strong uppercut to the chin of the national government. But wait, the national government fights back in Garcia v. San Antonio Metro Transit Authority, 1985. This case overturned the ruling of National League of Cities v. Usury. Justice Henry Blackmun, who had provided the critical fifth vote in the previous case, now reversed his ruling, saying that the National League of Cities rule was too confusing and didn't work in the lower courts. In New York v. United States, 1992, the Supreme Court ruled against a national provision of the Radioactive Waste Policy Act that required states to take title to waste they couldn't handle through a waste management program. The court ruled this provision allowed the federal government control over the state's legislative process and so therefore violated the 10th Amendment. Then, in 1997, in Prince v. United States, the Supreme Court ruled that it was illegal to require state law enforcement officers to run background checks on prospective handgun purchasers because the national government was forcing the states to enforce a national law. In Shelby County v. Holder, 2013, the Supreme Court invalidated a portion of the Voting Rights Act that required certain states to seek pre-clearance from the federal government before changing their voting laws. The federal government passed the law to make sure that any changes in voting regulations were not discriminatory, but instead, the court struck down this law because they said it was discriminatory against certain states and violated the state's legislative sovereignty. Could one more blow to the national government end up in a knockout? Let's look at one more case, Bond v. the United States. The initial case was in 2011, but the appeals lasted all the way until 2014. In this court case, Carol Ann Bond was arrested for smearing toxic chemicals on her neighbor's mailbox. She was tried for breaking the laws of the Chemical Weapons Convention, which prohibited chemical warfare. Bond appealed on 10th Amendment grounds, saying that the Chemical Weapons Convention violated the treaty powers of the national government and infringed on state power. She was initially denied her right to an appeal because the court ruled she had no standing, but eventually was granted an appeal. When the court ruled, however, it pushed aside the 10th Amendment argument and instead ruled on whether this really was a case of chemical warfare and so applicable under the Chemical Weapons Convention. They ruled that Bond could not be tried under the law, but made no mention to the constitutionality of the chemical weapons case or the 10th Amendment. See, the thing is, while there might be a power struggle between the states and the national government, that's how it's supposed to be. Each one checks the other, keeping either from delivering the knockout punch and taking ultimate power. If the Constitution is read too strictly, then every power that wasn't specifically given to the national government would belong to the state government. With each state having their own interests and ideas, things could get very confusing very fast. If the states gain too much power, then federalism is defeated just as much as if the states do not have enough power. The 10th Amendment is a very important part of keeping power balanced, which means the Supreme Court has a tough job when ruling cases that deal with the 10th Amendment. To tip the scales of justice either way could have a disastrous effect on the future of our nation.